There's one rather prolific commenter on the First Amendment auditing videos that likes to take exception to auditors saying that they're taking the videos for their own purposes. And he'll often link to this, or she, I don't want to assume anybody's gender, will often link to this website, freedomforuminstitute.org, specifically to this statement. 6 years later, the Supreme Court reiterated, to achieve First Amendment protection, a plaintiff must show that he possessed, one, a message to be communicated, and two, an audience to receive that message, regardless of the medium in which the message is to be expressed, citing Hurley v. Irish American Gay, Lesbian, and Bisexual Group. Now, I just want to say that this webpage is garbage. Do not believe a word this webpage says. It is terrible, and I'm going to use the links provided to show why you should never listen to Bill Kenworthy, legal researcher. And it was garbage back in April 2012 when he updated it too. These are old cases, so nothing's changed. I'm going to use his cases. I'm going to use the cases he cites in support of his positions to show how retarded he is. All right, so first we got photographs as speech. No Supreme Court decisions directly address a photographer's First Amendment rights. The rulings closest to that issue involve expressive speech and conduct. The First Amendment literally forbids the abridgment of speech, but we have long recognized that its protection does not end at the spoken or written word. We have acknowledged that conduct may be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. In deciding whether particular conduct, damn you, get in a new mouse too. There you go. In deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, we must be asked whether an intent to convey a particularized message was present and whether the likelihood was great that the message would be understood by those who viewed it. Now, they're talking about conduct in here. Now, photography is not conduct any more than standing on a soapbox shouting about the evils of abortion or about the evils of Donald Trump or the evils of the military-industrial complex or whatever evils you want to yell about it. Everything is conduct, but specifically conduct regulation is a very specific thing. This link right here he provides, lawcornell.edu, goes to here. This is Texas v. Johnson. In this case, Johnson wanted to burn a flag. Texas had a statute that said you can't burn flags. And the reason why they had a statute that says you can't burn flags is because they didn't want you to desecrate the flag. And the court said no. The court said no. And the reason why the court said no is because of U.S. v. O'Brien. U.S. v. O'Brien is where the United States had a statute that said you couldn't deface or destroy your draft card. And O'Brien burned his draft card to protest the Vietnam War. And the court held, the U.S. Supreme Court held, that when speech and non-speech elements are combined in the same course of conduct, a sufficiently important government interest in regulating the non-speech element can justify incidental limitations on First Amendment freedoms. A governmental regulation is sufficiently justified when it is within the constitutional power of the government and furthers an important or substantial government interest unrelated to the suppression of free expression, and if the incidental restriction on the alleged First Amendment freedom is no greater than is essential to that interest. Conduct restrictions you will be most familiar with in the form of trespassing laws. Trespassing laws restrict your conduct. They may end up restricting your speech, but it's incidental to them restricting your conduct. Burning a flag is a conduct restriction. The speech element is incidental to burning the flag. But in this case, the Supreme Court held that there wasn't a sufficiently important or substantial government interest, and they also held that the that the burning of the flag wasn't closely enough related to it because they're using it to prevent breaches of the peace and it wasn't narrowly drawn, et cetera, et cetera. And I feel justified in bringing in U.S. v. O'Brien because they bring in U.S. v. O'Brien in Texas v. Johnson. So I hope you'll forgive me. So if photography was some sort of performance art, then absolutely it would be conduct regulation would apply. But remember, there's three basic kinds of speech regulations that may end up applying to photography or filming the police and things like that. There's conduct regulation, which would be like trespass laws. There are conduct or viewpoint regulations, which would be like filming top secret, or classified installations. That's conduct or viewpoint regulation. And then there's time, place, and manner, which is, you can't use a bullhorn that exceeds X number of decibels. You can't be in the park after dark. Time, place, and manner restrictions. So conduct restrictions aren't going to apply to photography. The reason why they're not going to apply to photography because photography isn't a performance art. So it's stupid to talk about this, but we're going to continue on. Texas v. Johnson isn't going to apply to photography. I'm just going to go ahead and say it. Except in the form of trespass. 6 years later, the Supreme Court reiterated, to achieve First Amendment protection, a plaintiff must show that he possessed, 1, a message to be communicated, and 2, an audience to receive that message regardless of the medium in which the message is to be expressed. Now this is Hurley v. Irish American Gay, Lesbian, and Bisexual Group. That's this right here. This is the link they provide. This is, again, a U.S. Supreme Court case. Nothing to do with photography, obviously. This group, the Irish American Gay, Lesbian, and Bisexual Group of Boston, wanted to participate in the St. Patrick's Day Parade, and they sued to get their way in. Now, in this case, there's this. The protected expression that inheres in a parade is not limited to its banners and songs, however, for the Constitution looks beyond written or spoken words as mediums of expression, noting that symbolism is a primitive but effective way of communicating ideas. Our cases have recognized that the First Amendment shields such acts as saluting a flag and refusing to do so, wearing an armband to protest a war, displaying a red flag, and even marching, walking, or parading in uniforms displaying the swastika. As some of these examples show, a narrow, succinctly articulable message is not a condition of constitutional protection, which, if confined to expressions conveying a particularized message, would never reach the unquestionably shielded painting of Jackson Pollock, music of Arnold Schoenberg, or Jabberwocky verse of Lewis Carroll. So there is the painting of Jackson Pollock is unquestionably shielded. The music of Arnold Schoenberg is unquestionably shielded. The Jabberwocky verse, literally gibberish, is unquestionably shielded. Now you'll notice that they are quoting in deciding whether particularized conduct possesses sufficient communicative elements to bring the First Amendment into play. We have asked whether an intent to convey a particularized message was present. To achieve First Amendment protection, that's what we're quoting. To achieve First Amendment protection, the plaintiff must show that he possessed, 1, a particularized message to be communicated. Well, let's see if Hurley actually says that. 2. What? No, to achieve? Did I misspell it? No, to achieve. So, this quote that it is attributing to Hurley v. Irish American Gay, Lesbian, and Bisexual Group does not exist in Hurley v. Irish American Gay, Lesbian, and Bisexual Group. That tells you that this is very poorly researched. And you'd expect more from a legal researcher. So pay attention, Bill. Bill Kenworthy. You're a bad researcher. So, Hurley v. Irish American Gay and Lesbian, blah, 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 actually says that the Jabberwocky would be protected speech. Unquestionably shielded. So it doesn't hold what they think it's holding. But we'll continue on. So speech or conduct, taking photographs, that's so retarded. It's not conduct. That satisfies both the elements above is allowed and protected by in the public forum. That's so stupid. That is so stupid. He didn't even do a public forum analysis. Texas v. Johnson didn't do a public forum analysis. Hurley v. Irish American Gay, Lesbian, and Bisexual Group didn't do a public forum analysis. I mean, since they could control access to the parade, if they were going to do a public, or if they were going to do an analysis for the forum, it would at best be a limited forum, because the government was saying who could speak, and obviously if they were doing if it was a limited forum, since it was content and viewpoint, it wasn't viewpoint neutral. It was pro. These guys wanted to have pro-gay messages. Since it wasn't viewpoint neutral, then they would have failed a limited forum analysis. So I don't know why he's bringing up public forum analysis. He's just stupid. Using this crap guide, we can look to the courts and find one type of photography that is not protected by the First Amendment. Private recreational photography that's for one's own personal use. So he cites this big long thing by Ramsey Porat v. Lincoln Towers. Yeah. Porat took pictures on private property and public property and private property. He was charged with trespass because he went onto private property. It was never prosecuted. He ended up suing because they denied him his First Amendment right to film. And Porat, this is part of Porat. Now you may recognize this. To achieve First Amendment protection, the plaintiff must show he possessed a message to be communicated to an audience to receive that message regardless of the medium. So that quote that this fella attributed to Irish American Gay, Lesbian, and Bisexual Group, Hurley v. Irish American Gay, Lesbian, and Bisexual Group, was actually from Porat. Now, Porat is a district court decision, so it's not a terribly precedential opinion. And what do they cite? So for this guy's private, purely recreational, non-communicative photography, they cite Texas v. Johnson. Doesn't apply. We already know that. They cite Barry. We'll get to Barry. They cite Hurley v. Irish American Gay, Lesbian, and Bisexual Group, which they held that said a message had to be communicated, an audience had to receive the message. But we already know that Jabberwocky, liberal gibberish, not liberal gibberish. Sorry, I'm not trying to make a political statement there. Literal gibberish is protected. A Jackson Pollock painting, I'm not sure if you're familiar with them, but they're basically just splashes of paint on a canvas. And then it also cites Montefusco and Nassau County. Without an element of expression, there's no risk to the speaker or creator of art that his or her ideas or message will be unlawfully extinguished in contravention of the First Amendment. Now, that sounds bad, but they cite Montefusco v. Nassau County. What's Montefusco v. Nassau County? Montefusco v. Nassau County is a case where a school teacher and softball coach, girls softball coach, I think a high school teacher, took candid pictures of the girls and jerked off to them. And he took certain photographs which were the subjects of this litigation. He had them developed. The vast majority of the photographs, copies of which have been submitted to the court, are candid shots of teens, mostly females. After the photos were developed, blah, blah, blah. Montefusco claims he was where he was a school teacher and he coached a high school girls softball team. According to Detective McCauley's account of the interview, Montefusco also admitted he was a voyeur. They had similar photos in his garage at home and he'd use the photographs in private to masturbate. Blah, blah, blah. Anyway, what this court held, that I lost my place. Okay. Thus, the Second Circuit concluded in Berry that visual art is a wide-ranging description. I think I wanted to go on. Okay, here we go. There's no doubt the protection granted by the First Amendment extends beyond political speech and verbal expression. The Jackson Pollock painting would be protected. Thus, the Second Circuit concluded in Berry visual art is as wide-ranging in its depiction of ideas, concepts, and emotions as any book, treatise, or pamphlet or other writing, and is similarly entitled to First Amendment protection. However, it says, the Berry Court also recognized that images nonetheless must communicate some idea in order to be protected under the First Amendment. And they say Berry at 695. And on that basis, they said that this guy wasn't entitled to protection. So we're going to look at Berry 695. Now remember, Porat also linked to Berry by saying that there had to be a message to be communicated and an audience to receive it. That images must communicate some idea, right? So what does Berry have to say? We're going to go to 695. This is 695. So this is going on about a previous thing, but we're going to start here. I'll start out actually at 695. But our cases have never suggested that expression about philosophical, social, artistic, economic, literary, or other ethical matters is not entitled to full First Amendment protection. Motion pictures are fully protected expression that may, this is important to videographers, motion pictures are fully protected expression that may affect public attitudes and behavior in a variety of ways, ranging from direct espousal of a political or social doctrine to the subtle shaping of thought, which characterizes all artistic expression. This is Joseph Burston. This is one of the first cases on motion pictures getting First Amendment protection. So this is a U.S. Supreme Court case. So even if photography fails, you can see that that motion pictures definitely have full First Amendment protection. So then we're going to go on. Now remember, we're looking for where they say that you need, that it must communicate some idea in order to be protected under the First Amendment. It must communicate some idea in order to be protected under the First Amendment, right? So we're still in 695 because this is where they're saying the silver bullet is. The district court viewed the First Amendment's primary function as safeguarding the free flow of political and religious views, and hence felt sanguine about the ordinance's interference with appellants' wish to sell their apolitical paintings. The city apparently looks upon visual art as mere merchandise, lacking in communicative concepts or ideas. Oh, so that's what the city thinks. The city thinks that visual art is lacking in communicative concepts or ideas. Both the court and the city demonstrate the lower court and the city demonstrate an unduly restricted view of the First Amendment and of visual art itself. Such myopic vision not only overlooks case law central to First Amendment jurisprudence, but fundamentally misperceives the essential visual communication and artistic expression. Visual art is as wide-ranging in its depiction of ideas, concepts, and emotions as any book, treatise, pamphlet, or other writing, and is similarly entitled to full First Amendment protection. Visual art is entitled to full First Amendment protection. Indeed, written language is far more constricting because of its many variants, different languages, among and within each group, and because some within each language group are illiterate and cannot comprehend their own written language. The ideas and concepts embodied in visual art have the power to transcend these language limitations and reach beyond a particular language group to both the educated and the illiterate. As the Supreme Court has reminded us, visual images are a primitive but effective way of communicating ideas, a shortcut from mind to mind. Visual images and symbols, for example, are used in the third world so that individuals who are unable to read may readily recognize the party or candidate they wish to vote for. One cannot look at Winslow Homer's paintings on the Civil War without seeing, in his depictions of the boredom and hardship of the individual soldier, expressions of anti-war sentiments, the idea that war is not heroic. Furthermore, written and visual expression do not always allow for neat separation. Words may form part of a work of art, and images may convey messages and stories. As appellants point out, Chinese characters are both native and pictorial representations. Nahuatl, a language used by the Aztec peoples in Central America, also incorporates pictures in its written language. Visual artwork is as much an embodiment of the artist's expression as is a written text, and the two cannot always be readily distinguished. We're running out of room here before Barry shoots down photography on 695. We're really running out of room. The city argues that appellant's expression allegedly impinged by, remember, this is the city's argument. The city argues that appellant's expression allegedly impinged by the regulation is not, in fact, their art, but their peddling of the art. It argues that the sale of art is conduct, and in order to be constitutionally protected, the sale of protected material must be inseparably entwined with particularized message. The city further argues the appellants are free to display their artwork publicly without a license. They simply cannot sell it. So the city is arguing that it's the sale of art that is going on here that they're trying to regulate, and that's conduct, right? That's the city's argument. You staying with me? These arguments must fail. The sale of protected materials is also protected. It is well settled that speakers' rights are not lost merely because the compensation is received. A speaker is no less a speaker because he or she is paid to speak. And we're out of page 695. So what they were claiming existed didn't exist. And then we're going to go on down here. The district court seems to have equated the visual expression involved in these cases with the crafts of the jeweler, the potter, and the silversmith who seek to sell their work. While these objects may at times have expressive content, paintings, photographs, prints, and sculptures, such as those that appellants seek to display and sell in public areas of the cities, always communicate some idea or concept to those who view it, and as such are entitled to full First Amendment protection. I'm going to repeat that sentence. While these objects may at times have expressive content, meaning the previously stated items, the crafts of the jeweler, potter, and silversmith, paintings, photographs, prints, and sculptures, such as those appellants seek to display and sell in the public areas of the city, always communicate some idea or concept to those who view it, and as such are entitled to full First Amendment protection. So Barry does not support the holding of Montefusco. Barry does not support Porat. So this writer is retarded, but we will continue. He then goes on to point to, in 2010, a federal court in Indiana found there's no First Amendment right to videotape a school choir performance. He was prohibited from videotaping the performance in which his daughter was singing because the school has no videography rule for that particular event. What would that be? That would probably be a time, place, and manner restriction. Or if it's a limited public forum, then they can control. I know you guys don't believe this, but schools can prevent you from filming, even if like you buy a ticket to go and watch a play at the school, and the school has opened up the auditorium to the public for that purpose, then they still can prevent you from filming it. All right, so he links to this Larson v. Fort Wayne Police Department. And if I remember correctly, this went nowhere. Yeah, so these are filings, and I could pay for Pacer to get them, but this is just a. I thought this was a magistrate. Yeah, it's a magistrate. Magistrates are one step below district court judges, so they typically don't have a whole lot of sway. Yeah. So I don't know why he's citing magistrates. It's pretty retarded. Thus, lower courts have found that non-communicative recreational photography is not protected by the First Amendment. He had to go out of his way to find lower courts that held that recreational photography is not protected by the First Amendment. I mean, if you're citing magistrate decisions that aren't even published, it's not even published, for God's sake. I mean, it's a magistrate court decision and it's not published. He had to go to oh, Christ. Thus, lower court, blah, blah, blah. All right, so as Judge Prescott wrote in Porat, it doesn't matter what Judge Prescott wrote. All right. So then in 2006, a federal district court, another district court in New Jersey. So now he's saying that he's gonna tell us the level of protection given to communicative photography. All photography is communicative, as we've already found out, but we'll play his stupid game. And this is Maureen. I'm going to call her Maureen. Maureen versus Borough of West Wildwood. Sorry, I'm terrible with Polish names. So Maureen versus the Borough of West Wildwood. Let's see what they talk about for photography in this case. All right, Maureen. All right. So, according to Maureen, she only took a picture of Officer Ferenc or her patrol vehicle on 3 separate occasions, and all 3 times Maureen believes she was documenting the officer's duties or activities on duty. She threw away the camera without developing the pictures. This is the big deal that we're going to look at here. This is what's going to tell us that this is what's going to tell us the level of protection communicative photography is given. This is so retarded. I don't even know I'm doing this now. All right, so Maureen asserts her arrest for stalking violated her First Amendment rights. Institution of criminal action to penalize the exercise of one's First Amendment rights is a deprivation cognizable under 1983. To establish a claim outside the employment context, she must demonstrate that she engaged in protected activity. The government responded with retaliation, and the protected activity was the cause of retaliation. Maureen asserts that her arrest for stalking was an attempt to silence Maureen in retaliation for actions taken in furtherance of her political activism. Namely, photography. No. Namely, monitoring the actions of Officer Ferenc and Mayor Fox and voicing her concerns about their alleged improper conduct to other community leaders and concerned West Wildwood citizens. Maureen has put forth sufficient evidence that she was concerned citizens who at times took photographs. Who at times spoke her mind to borough officials and other citizens about her concerns regarding the official conduct of the police department and the mayor. Such photography, nope. Such speech is clearly protected by the First Amendment. The major purpose of the First Amendment was to protect free discussion of governmental affairs. Protections given to speech and press were fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Additionally, Maureen has brought forth sufficient evidence to defeat summary judgment with respect to the second and third prongs of her First Amendment retaliation claim, and blah blah blah. So, the first prong was what would have said that she was engaged in protected activity. That's what we were looking at. The second was the government responded with retaliation, and the third was that the protected activity was the cause of it. So there was no 1983 claim over photography. So this jerkwad wasted our time in talking about that. And once again, it was another freaking district court case. Like, Christ, dude, district court cases. And then he goes on to California case. It's Quivalo v. City of Oakland. This one right here, this is a magistrate judge. See, Edward Chen, magistrate judge. This one is misleading because it's based on the California Constitution, which gives expanded protections over what the U.S. Constitution does. Basically, the activity has to be incompatible with the use of the area in order for the government to regulate it. But even then, he screws it up because he says the circuit court affirmed Chen's ruling in 2011, and it sounds similar, Quivalo v. Oakland, but this one were entirely different. This one is about them being able to access the Oakland Coliseum, particular ramp, the Oracle Arena portion of the Oakland Coliseum, to take pictures of the elephants as they entered. This one is about a couple different things. There's a buffer zone in the Cow Palace, which is not the Oakland Coliseum. And there was another one, compound perimeter walkway. Yeah. So it's an entirely different case, but he was stupid, and he even gave a bad link to it because he gives us that, which is not a case. So I don't know what this dude's smoking. There was another Quivalo. This is the same Edward Chen, who's now a district judge. He's moving on up in the world. Anyway, he got to give a permanent injunction, so he moved up. He went from a magistrate judge in 2007 to a district judge in 2012. So good for Chen. But again, it had nothing to do with photography. It had nothing to do with. It had to do with access. It was a time, place, and manner restriction, ish. Basically, in this case, the Oakland was only allowing ticketed people up into this particular section of the Oakland Coliseum, and the plaintiffs didn't have tickets and they wanted access to it. So it didn't really have anything to do with photography. Yeah, they wanted to photograph when they were there, but I mean, they couldn't be there even if they didn't photograph, so it wasn't really related to it. And it was a magistrate and then a district court decision, and it was based on the California Constitution. So again, stupid, and stupider. Finally, we've got this case that they talk about, this Lambert v. Polk, where the Bo Lambert took video of a guy who was killed. There was a street fight where somebody died. The police took it, and the court held that it was probable that Lambert tried to be free from unreasonable search of his property was violated, that his right to not be deprived of the property without due process of law was violated, and that concomitantly means at the same time his First Amendment rights were violated. What First Amendment rights were those? His First Amendment right to display the tape and disseminate it in any way he wishes. It's his First Amendment right to display the tape and disseminate it. Not to take video, but his right to display the tape and disseminate it. Nothing to do with photography. Well, I guess tangentially. I mean, after you take the picture, you have the right to display the picture and to sell the picture or otherwise pass it around. Anyway, this is just a terrible website. I hope I've beaten it up enough that you understand how stupid it is. I used the very sources that this author used to show you how stupid he is. It is very possible for district courts to be stupid too, as we saw with Porat and, what is this one, Montefusco. I think Montefusco just really wanted to nail this bastard, the guy who was jerking off to the teen girls. So I can kind of see why they did it. It'd be nice if they stuck to the letter of the law and didn't try to cheat, go around it just because some dirty old man's jerking off to candid pictures of little girls. But whatever, you know, I just value the First Amendment, even for pedophiles. Sorry, Felipe, but even pedophiles have First Amendment rights. Well, I hope you enjoyed this, and have a great